Today we're joined by Dr. Cox, who is a senior lecturer at Portsmouth Law School. In 2015, she launched the university's Ivory Project with the aim of investigating the sale of ivory by the British antiques trade. The 18-month project culminated in the launch of the Elephant in the Sale Room. The report calls for stronger regulations regarding the sale of ivory artifacts. It also tried to understand the effect further restrictions would have on the British arts and antiques market. The report was used by the British government to assess potential changes in law, and finally in December 2018, the Ivory Act became law. Caroline's research interests include the use of online platforms to facilitate the trade of trade in endangered species and human-animal conflict in the range states. Today, she will speak to us about the legal framework within Europe, explain the processes involved in accessing court data, types of evidence used by data collection, types of evidence used for data collection, the privacy laws and practices, and how to submit the official data request. I will now hand over to Dr. Caroline. Welcome, and you can now take over.
Thank you, Lele. Thank you very much. So as Lele's mentioned, I'm a senior lecturer at Portsmouth Law School, part of the University of Portsmouth, and my entire research life has been around the illegal wildlife trade, and more specifically the illegal ivory trade. So the biggest project that we've really done so far is the work on the Elephant in the Sale Room, which led into the government's consultation paper for what was then the Ivory Bill, but has now become the Ivory Act. And we were honoured to have been able to play a small part in that. So that's me. My whole research work is on the illegal ivory trade, and specifically looking at the way that the ivory trade has been able to come off the shelves and move online. And for me, that I think is the biggest threat to elephants now. I'm currently working on a project that looks at mammoth ivory. Now, of course, I know mammoths are extinct, but CITES is actually looking at adding mammoths to its list of protected species because of the fact that a mammoth tusk is so similar to an elephant tusk. Sale of mammoth ivory, which is currently legal, can be used to mask the sale of elephant ivory. So that's going to be a very important one moving forward. So keep your eye open for that, everyone. And maybe that's something that you guys might want to have a look at later down the line of your own investigations. So what Roxanne has asked me to really concentrate on today for you is how the legal framework works within the European Union. Now, of course, the UK is no longer part of the EU. And so when I'm talking about the European Union and the legal regulations, I'm really just focusing on the EU member states. No longer am I able to talk about the UK as a member of the EU. If we've got a little bit of time at the end, I can tell you a little bit about the UK regulations, because I know that at least 2 of you are based in the UK and working out of the UK. So that may be something that you're interested in hearing about. So if we have time to do that at the end, I'm very happy to answer any questions as far as I'm able to about UK specific legislation and regulations. But today we're really focusing on the European member states. So Roxanne said, oh, can you give us a little bit about court data and how my journalists can access court data? And actually, you're going to see that the EU is very, very well set up to enable journalists, anyone really, to access the data that they have. So it's not as horrific as you may think. The real problem for you guys is that there are 20 odd members of the European Union, And although they are under an umbrella of EU regulations, they are all sovereign nations. Then nobody gives up their sovereignty to become, despite what the British think, nobody gives up their sovereignty when they become a member of the European Union. So there are slightly different things at play in each of the member states. So I'm just going to give you the overall EU umbrella today. I've mentioned to Roxanne already that if any of you ever come across an issue where you think, I really don't know what to do here, I don't know where to go to get this information, I'm not sure if I'm able to do this, Roxanne has my contact details, so please feel free to drop me an email if you'd like to. And one of the most important things that you guys will need to do is submit a freedom of information application to one or other of the EU bodies. So I'm just going to give you a little bit of information about how it is you go about doing that. It is actually really, really simple, because remember, the EU is set up to be collaborative, and so getting information from EU organizations is pretty straightforward. I'm probably teaching you guys to suck eggs here, because I know you're all very experienced journalists, but I thought it was really useful to kind of start off our discussion this morning really thinking about what it is we mean by a wildlife crime, what it is we mean by an environmental crime. Now, my specialism is in environmental crime. Some of you I know are interested in other areas of environmental crime. All of them are part of a genre called green crime. And this is a criminological definition, really, about crimes that are directed against sentient beings, so beings with feelings, beings with emotion that are not human. So we're talking about crimes against wildlife in the main when we're talking about these types of green crimes. And there are two types of green crimes. There are direct crimes where, I don't know, poaching, a direct green crime. And then there are secondary or indirect crimes. And these are the crimes that I know you guys will spend an awful lot of time thinking about. And this is what will take up a lot of your investigative time and energy. It's those crimes that are carried on almost behind the curtain, behind the scenes, that enable a wildlife crime to take place. So it's things like money laundering, documentation falsification, all of those things that go on behind the scenes. And when I think about these secondary crimes, in my head, I'm thinking really about organization type crimes. But we mustn't forget those. You know, for most people, when you say wildlife crime to them, of course they think about elephant poaching or pangolin collection or the destruction of a rainforest. But behind that act, there is an awful lot going on that facilitates the act, and it's organized. And so that's what really I'm talking about when I talk about the secondary crime. Now, for you guys today, you're really wanting to know about how do I get to the information I need to be able to write my piece, to be able to carry out my piece of journalism. And accessing information is really quite simply knowing who it is you can go to get the information that you want and you need. You know what, the EU, indeed any national or international organization, it can be a little bit like a black hole stepping off the precipice into this pit of darkness, and thinking, where do I go next? Who do I ask for this? That is what it can feel like, and I hope that today I'll be able to help you work your way through that minefield just a little bit. And the last thing is the legal systems. What are legal systems? Quite simply, they are a set of laws within a specific jurisdiction, or a set of laws between jurisdictions. So you might have heard of national law and international law. So if I'm talking about national law, for me, I'm talking about the law of the United Kingdom, set out by Parliament, dealt with by the British courts, simple. If I'm talking about international law, I'm really talking about the way the UK acts with another sovereign nation state, and what law is in place to deal with the way two sovereign nation states act. Now, when we're talking about the European Union, of course, we're talking about another level of something in between. It's not national law. It's not really international law either. There is a group of regulations, that's what the European Union call laws, directives, that deal with how the member states of the European Union work. And the idea is that we all, or they all, work from the same rule book. So everybody has a basic set of rules. They're fine to go beyond those rules, but they must all abide by a certain set of rules. And there are two big international pieces of legislation, conventions really, that I wanted to mention to you because they're directly relevant to the work that you guys do, and you'll be very, very well aware of them already. The first one is the United Nations Environmental Programme. The second is, of course, the CITES Convention, the Convention on International Trade in Endangered Species of Wild Fauna and Flora. So both of these conventions are binding on the parties who are signatories to them. So let's take CITES as an example. 183 nation states are signatories of CITES. The UK was one of the first to become a signatory of CITES, and there are many, many since then. So 183 sovereign nation states have all signed up to the CITES agreement, and that is binding on them as a piece of international law. So let's have a little think about the European legal framework and how international law works with the illegal wildlife trade. So I don't need to tell you guys, you're dealing with this every single day of your professional lives. I don't need to tell you what a serious threat the IWT is to our planet, our ecosystem, to every single one of us. I heard an amazing person speak a few years ago who said, you can't take one link out of the chain and expect the bicycle to run. And that's exactly how the planet is. Everything is interlinked. And so when we take one species and wipe it out, we don't just lose that species, we lose an ecosystem around that species. So the IWT is a huge, serious, very serious threat to our planet. Often with the IWT, we're not just talking about a trade in wildlife products between local people. We're not talking about a small area. We're talking about an international trade, and we're talking about a trade that's transnational, and that's really where the organization of the organized crime bit comes into it. Now, the CITES Convention, 1975 convention, it was originally set up because the world could see there were threats to the planet's ecosystem through the loss of key species. So the CITES system, sometimes it's described as the Magna Carta for wildlife. But the CITES system is really there not to stop specifically the trade in endangered species, but to regulate the trade in endangered species. So CITES will, every few years at their meeting of the parties, look at different species and consider where they should be on its appendices, how important that species is, and how at threat that species is. And the idea of CITES is to ensure that international trade in a specific species of animal or plant or whatever doesn't threaten the survival of that animal or plant. So CITES does not ban the international trade in endangered species per se, but it regulates the trade in endangered species to ensure species don't become extinct. That's the idea. So I said that the UK was one of the very first signatories to CITES. Well, the European Union is also, as a bloc, a signatory to the CITES Convention. Now, because CITES is a piece of international law, it doesn't immediately have effect on the nations who decide they want to be members of CITES. You need to have a piece of legislation in the home nation to ensure that CITES works within your jurisdiction. So let's take the EU. The EU actually has a set of regulations, and they're called the EU Wildlife Trade Regulations, and they mirror what CITES says. So these EU Wildlife Trade Regulations are binding on all the member states of the EU. And in actual fact, those regulations, the EU regulations, actually go further than the CITES appendices do. So they're really, really strict, and they are binding, directly binding on all members of the EU. So I'm hoping you're starting to see a bit of a pyramid. Sorry, I've just come back from Egypt, so pyramids are still on my mind, where you have CITES at the top of your pyramid, kind of giving guidance, saying this is what we want to protect, this is why we've got to protect it. And then below CITES, you have the European Union saying we want to adopt everything that CITES is telling us. We want to ensure that these species don't become extinct. We want to make sure that our member states, the members of the European Union, abide by CITES. So we'll have our set of regulations. And then below that, each EU member state will encompass those EU regulations into their own national laws. So each of those states, by this trickle-down pyramid effect, will be encompassing what it is that CITES is setting out to create. So in the EU, there are several really key nature and biodiversity protection initiatives. I think the big one that most of us have heard of is called the EU Birds Directive. This is really to protect birds that are migrating to and from the European Union. You will have seen that in some, certainly southern European nation states, there has historically been quite a tradition to trap migrating birds, and the EU Birds Directive has been set up to really combat that practice. The second one I wanted to mention specifically is called the EU Habitats Directive. So under the EU Habitats Directive is protection for over 1,000 different species of animal and plant and 200 different types of habitats. So everything from marine habitat to swampy marshland habitat to grassland habitat. These are protected under the EU Habitat Directive. Why? Because everything is connected. Remember, it's a chain, and if you break one link in the chain, the bicycle won't work. So if you don't protect the habitat, you can't protect the animal. If you don't protect the animal, everything is going to fall down. Some of you will have come across Natura 2000 areas. This is something that was set up by the EU to establish a patchwork, a network of protected sites across Europe. And the idea is these protected sites are very strategically placed so that they can coordinate breeding areas, nesting sites, for species of a bird and animal that are particularly at threat. So it's a very, very useful way of providing wildlife corridors effectively. That's the idea. So an animal, although an animal may graze in one place, it may go to another place to have its young. So Natura 2000 enables that connectivity between breeding and breeding spots and grazing spots, etc. And the final thing I wanted to mention to you was the EU biodiversity strategy. Now, this is a 2030 strategy, so this is a forward planning strategy. And the aim of the strategy is to ensure that Europe has in place a means of recovery for its biodiversity. And that's really key. And Natura 2000 is a very important aspect of this new strategy to protect habitat areas, to protect species, and to protect breeding sites particularly, and to have corridors between them. So there, although we have several different things I've mentioned to you there, the really key ones, I think anyway, are the EU Birds Directive and the EU Habitats Directive. I can remember many years ago being horrified when I heard that wild birds were trapped in netting traps in the southern Mediterranean states particularly. And thought, what an awful thing to do. And the EU Birds Directive has done a lot of work to stop that continuing. The Habitats Directive is so key and so vital to the protection of the European Union's natural landscape, really. It's easy to do it, easier, let's put it that way, to do it if you're just dealing with one nation state. Here in the UK, we have a number of initiatives aimed at the protection of the natural world. The National Parks scheme is probably one that you will have all heard of. But when you're trying to do that on a transnational scale across 20 odd European nations, it's a very difficult thing to do. So to have the EU Habitats Directive there is an incredible piece of legal work. Now, of course, when you have these various directives in place, that's all very well, but you and I both know that the problem with human beings is if there's a law, they're likely to break it, or at least some parts of our system is likely to get broken. And that's why the EU has backed up these initiatives and directives with criminal legal clout, and that comes through the Environmental Crime Directive. And what the Environmental Crime Directive is able to do is ensure that there's environmental protection through the criminal law. So it's not simply a case of, oh, we'll fine you. It can be a case of, we will jail you if you break this directive. So this is, if you like, the bird directive and the habitats directive. That's the carrot. That's the carrot. That's the part of the EU that's saying, you know, look at how beautiful, look at how we can save and develop our natural environment if we do this, this, and this. That's the carrot. The environmental crime directive is the stick. That's saying, if you break this, if you break these laws, you're going to go to jail. So we have carrot and stick together here. Now, in the European Union, when we're talking about environmental crime, it's covering quite a broad aspect of crime, really. It's talking about breaches of environmental legislation, and it's talking about anything that causes harm or risk to the environment and or human health. So it's very, very broad. So the new EU strategy to tackle organised crime is going to be really, really important for environmental crimes, and specifically to the type of crime I'm interested in, wildlife trafficking. In fact, the EU strategy to tackle organised crime specifically mentions wildlife trafficking as an area that it's going to be looking at very closely. So this is certainly something that you guys are going to be looking at, I'm sure, in the work that you do. So I've mentioned my pyramid. EU directives, you know, like the Birds Directive, they need to be like a piece of international law. They need to be transposed into national law at national level. So let's think about a country like France, for instance. France is a member of the European Union. A new EU directive is passed. How do the people of France see that as a piece of French law? Because of course, you know, these are nation states that are bound together over a common aim, but they are not the same country. So how do they do that? Well, the EU directive has to be transposed to the local national legal system. So that's what happens. The EU member state will transpose the EU directive into their own national law. And, you know, that's normally done through regulations, and it will mirror the EU directive itself. It's up to each European member state as a sovereign state to decide on its own criminal system. So you will see differences in how different member states deal with environmental criminal law, because it will depend on their own legal and judicial system. Not dissimilar really to CITES, the domestic law of a European member state can go beyond the requirements of the EU directive. That's absolutely fine. What the EU does is lay down the baseline. This is the minimum you've got to do. But it's absolutely fine for member states to go beyond that and make it stricter. So I know that you guys are going to want to be able to get access to court cases, information from court cases, etc. And I thought the easiest way to do this is to point you in the direction of a couple of databases that I certainly use in my research. Now, the only thing that I'm going to flag to you here is there is sometimes a lag between the case coming to a conclusion and it being updated to the database. So you do need to be aware of that. The first one is the ENP database for environmental case law. And this supports environmental public prosecutors. So if you're an environmental public prosecutor and you are looking to go after a particular individual for a breach of a particular crime, you can go to this database and see what similar crimes have been successfully or perhaps not successfully prosecuted in the past, and you can use those cases for your own case. This is very, very new. I have to warn you guys, this is very, very new. I think when it really comes to fruition, it is going to be a fantastic resource for you. At the moment, however, they've only completed the first section of it. That's the waste section. So that is that's live and it's being updated, etc., etc. They are still developing the air pollution and the wildlife sections. So keep your eye on that, because that is going to be a brilliant resource for journalists and academics, frankly, alike. The second one is one that you may have come across in your work before. It's called Legal Atlas. Legal Atlas have developed a really, really comprehensive database. You have to register to become a user of it. I've registered, so I have access to this database. And if this is something that you're going to be doing a lot of us, I'd highly recommend that you do as well. It covers the world. 70 plus jurisdictions are covered by Legal Atlas, and they give you information on legislation, prosecution data, court case, so you'll be able to download the court case itself and read what happened in the court case. It's a very, very good legal database. There are some other very useful databases as well. Of course, Traffic have the Traffic Wildlife Trade Portal. This is excellent. It's an interactive tool. It has lots of open source wildlife seizure and incident data on it. Traffic EU Twix. The EU Twix contains data about seizures and offences, and it covers the whole 27 EU member states. In addition to that, it also covers Bosnia and Herzegovina, Iceland, Switzerland, the Ukraine, and the EU. Those latter states are, of course, not members of the EU. However, they are covered by the Traffic EU Twix. And although, you know, Traffic originally developed Traffic EU Twix to help prosecutors, so law enforcement agencies, etc., it can be used by journalists and also by academics to get access to seizure data and offences. So very, very useful thing to have in your toolbox, no doubt about that. The other one is the ENP database for environmental case law and related documents. Really, I've said quite a bit about that already. It's early days for it, but do keep your eye on it because it is going to get better. They are adding the wildlife crime and environmental stuff to it, so it will get better as it goes on. So lots of places to go that have already done a lot of the legwork for you, which is important for you guys, because if you can find ways to collect the information that you need that isn't going to take you masses of time, you've got more time to devote to your story. So those are all excellent, excellent means of gaining information. So what's the downside? Well, of course, privacy. There is a really important role that we all need to understand between what the media is doing in reporting on a story that's in the public interest and the rights of the person being reported on, their rights to privacy. So I just wanted to underline for you guys the principles of data privacy, and they are: it must be lawful, it must be fair, transparent, limited in terms of its purpose, data minimization, storage, and accuracy. And as journalists, as investigative journalists, your role is so vital in bringing to the attention of the public, governments, prosecutors, incidences of environmental and wildlife crime. And because we the public, rely on you, the journalist, to such an extent, that means that you have to act with the highest professional and ethical standards in everything you do. I need to know that when I read your piece or watch your piece, that what you're telling me is right, and that what you're telling me has been collected lawfully. Because if it hasn't, you've wiped out all of that good work, and that's what you need to avoid. So yes, you are there to inform, educate, and entertain, but you must do it professionally and you must do it responsibly. So how do you do that? How do you make sure that you are acting professionally and responsibly? Well, what you have to do is take reasonable steps to ensure that you are disseminating accurate and balanced information, and that the comments you're making, because remember, you know, you're not an academic. When I write a piece, I have to cite. You don't have to do that. Your views, your comments have to be genuine and honest. And it's because of this link between you and your reader, or you and your viewer. As a reader, I'm looking to you for information. I'm looking to you for honest information. And that's what you need to be able to say you're giving me. So that means never publishing anything that's false or malicious, never publishing anything that's unfounded, and never publishing anything that's intended to harm maliciously. Freedom of speech in the European Convention on Human Rights. So the good news for everyone in the EU, and the great news for you guys as professional journalists working within the European Union, is everybody has the right to freedom of expression. And this, under the freedom of speech, the European Convention of Human Rights, includes the right to freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. So the good news for you guys is that what the EU is saying very clearly here is, we want and we appreciate journalists. We want you to be able to tell us what's going on in the world. We want you to hold opinions, and we want you to impart information. So we have the EU Charter of Fundamental Rights, and it stipulates that all European Union citizens have the right to have their personal data protected. Now, that may seem to come into direct conflict with you having the right to have an opinion on anything, or indeed anybody. So you have to balance these two absolute rights. Your right to say what you feel is true, and the EU citizens' right to the protection of their personal data. Now, there's general data protection regulations, which everybody's heard of, I know, to the nth degree. And then there's Data Protection Law Enforcement Directive, which is the EU directive that specifically protects people's personal data. So the directive itself, it's phrased in quite a strange way: the protection of natural persons regarding processing of personal data connected with criminal offences or the execution of criminal penalties, and on freedom of movement of such data. So if I give you an example, you'll know what I mean. When you're in court, or when you are reporting on a court case, perhaps, you'll notice that while that court case is going on, before there is a verdict, you won't be told in the court case, although the information is out there, you won't be told what previous offences the person in the dock has committed and been found guilty of. This is why you have that personal information, and that personal data is protected. Once the person in the dock has been found guilty, that does change and it becomes a matter of public knowledge at that point. But while there is a criminal offence that is being prosecuted ongoing, their previous criminal penalties are protected from public. So section 40, it's Article 42 of the European Convention on Fundamental Rights, says any citizen of the Union and any natural or legal person residing or having its registered office in a member state has a right of access to documents of the institutions, bodies, offices and agencies of the Union, whatever their medium. So you, as journalists based in the EU, have the right of access to any document that is held by a European Union institution. You can ask for it in any medium you like: email, letter, fax, it doesn't matter. You have that right. So what does that mean for you? Well, all the rules about how you access EU documentation are set out in a specific regulation, and I've given it for you on the slide here so that you can have a little look at that in your own time. And this is particularly dealing with public access to the European Parliament, the Council, and the European Commission's documents. Finally, I promised I'd give you a few tips on how you actually submit a request for information. You can do it in any written form. So it can be a letter, it can be an email, it doesn't matter, any written form. There are 23 official languages of the European Union. If you are lucky enough to be able to speak more than one of them, you can submit it in any of the official 23 languages. You can also submit your request using the Ask the EU app. Simple. I put the link there for you. Clickety click on that and you can fill out your form. It's always free of charge. They never charge you to submit your requests for information, and they will only charge you if you're asking for hard copies of the information to be sent to you. They'll charge you the copying fee. That is it. So it is very open. How do you go about doing it? Well, I've given you a template, the suggested template, the EU's suggested template, as to how you can go about submitting your request for information. It's really simple. Under the rights of access to documents in the EU treaties, as developed by Regulation 1049/2001, I hereby request access to the following documents, and then you set out which document it is that you want. I prefer this information to be sent to me in whatever format you want it sent to you. There you go. And it's as simple as that. And I hope, everyone, that's given you, I'm afraid it is a very brief outline, but a brief idea as to how to go about accessing information and documentation from the European Union.